Okay, welcome to this evening's webinar. I'm excited. So I'm Sarah Larby. Many of you probably know who I am. I'm joined today by my wonderful business partner, executive assistant, right-hand woman, Aisha Govani. Aisha, welcome.
Hi, Sarah. Hi, Ryan. Good evening, everyone.
Good evening.
Hello.
And Ryan Carson will do an intro with Ryan very shortly. But Aisha, for those of you that don't know, has also started her own podcast and guest hosts on mine once in a while as well. What's the name of your podcast, Aisha?
So our podcast is Insights to Investing, formerly known as the Everyday Investor Podcast. We now have rebranded to Insights to Investing. So we'll be talking about all things investing, from real estate to crypto, to stocks, any way we can help people learn to passively make income to really reach their goals is what we'll talk about on the show.
Very cool. And Aisha is also a real estate investor as well. So many of you probably know we also started a YouTube show called the Multifamily Investor Show, where we're showcasing, often it's our buildings or buildings that, or houses, they're not always buildings, but multifamily properties that are under contract, purchased at different stages of the renovation. Some of them are finished. So if you guys enjoyed the show, feel free to add that in the chat. Let us know how, if you've seen the episodes. If you haven't, the Multifamily Investor Show, subscribe to that, because we have lots of great episodes and we film, and sometimes we bring in guests as well, like guests who have really cool properties, have done really cool projects. And Ryan is one of our experts on the show. And so you'll see from and hear from Ryan on every single episode. Ryan Carson's been my go-to lawyer for many, many years. So he's helped me not only with closes, some of them were quite complex closes with big buildings that, we had like time and pressure, and his team has always pulled it together and made things happen. But he's also helped me with my JV agreements. He's helped me strategically with, what kind of corporations I should have for what, and just educated me a lot, even with like the LP, GP structures and how that works and all that good stuff. Because when I first started real estate investing, I was doing it by myself with my spouse, Matt. Some of you may know him. He doesn't show up to many events, but he comes and does the social stuff once in a while. So you'll see him there. But essentially, until I left my 9-to-5 job, I didn't do a whole lot of JV stuff. So Ryan and his team have really helped me put it together. And I think in the last 6 months, like we've done 10 new projects, and always some fun stuff on the go. We've got a really cool hotel under contract right now. We're doing our due diligence on, it's like an old haunted hotel, potentially with 14 units. So there's some due diligence to be done there, but I'm excited for that. And Ryan and his team at Carson Law have been instrumental in making things happen. And just having that access to somebody that's done it for so many years. And you also have, I believe, other arms to your business as well. So welcome, Ryan.
Thank you. Thanks, Sarah. Thanks for having me on tonight. I'm happy to speak with everybody, and I'll kind of present tonight, but feel free to add questions as I'm chatting. Everybody who's listening in the chat section, and Sarah and Aisha are going to just jump in and tell me if there's a question that needs answering. So it won't be overly formal or anything. Feel free to ask anytime.
Yeah, guys, jump in, and this is your opportunity right now for any question that you ever wanted to know about joint ventures, how to structure them, what clauses. Like, this is, it's a free webinar. The only thing that we do ask is that you subscribe to our YouTube channel, The Multifamily Investor, to start listening to those and seeing those. But aside from that, this is a good opportunity to have an open discussion about everything to do with JVs. So Ryan, feel free to start, and guys, put your questions in the chat.
Perfect. Yeah. So I'll share my screen and start chatting, and then we'll see where this goes.
Perfect.
Thanks so much for introducing me again. Thank you. Okay.
And we have some questions. We won't start right now, but Alex, thank you for your question. We'll get to it probably as Ryan goes through some of his stuff. I'm sure it's part of that.
Okay, so as was stated by Sarah and Aisha, we're going to be talking about scaling your portfolio in real estate investing, and specifically, what are some corporate and business structures that you can utilize to help you do that. And so one of the most common ones that we're going to be talking about are joint ventures. But we'll also come back to this slide and talk about some potentially maybe lesser known options that are available out there, like corporate structure, corporations. How do those work with holding companies? You might hear that phrase. What also is important if you have corporate structure, meaning shareholder agreements. You heard possibly Sarah mention in her intro there about GP-LP structures. So what is a GP-LP? Like, what is that? And what about trusts, and how do those kind of factor into potentially what's involved here? So we'll talk about these in a moment, but I know most people have probably heard of or are using joint ventures or JV.
Actually, Ryan, that's a great point. Let's ask guys in the chat if and just select to everyone so everyone can see it. If you've done some JVs, put yes. If you haven't, put no. And then we'll get an idea of who's done some JVs in the past and who hasn't. All right, awesome. Okay, so a few people know, a few people yes, some people are newer. All right, nice. Okay, all right. So there's a mix there for you.
Okay, so I mean, let's talk first about what is a joint venture agreement, because that's probably important just to make sure we're all on the same foot. So it's a legal document, and the legal document basically allows you to encapsulate within it all of the terms that are going to exist between you and whoever you're involved with as a quote unquote partner in your real estate investing projects and properties and so forth. So for example, if we just use me, Sarah, and Aisha as an example, we're going to be co-venturing together. We're going to be all part of the joint venture agreement. Well, the first question is, who should consider being in the joint venture together? Well, if the three of us are doing a project together, or we want to do 3 projects together, we want to decide and enter into terms, we could use a joint venture to do that. So really the answer of who could consider being in the joint venture is anyone. Any real estate investor could decide to use a joint venture. Joint ventures, like I said, it's just a legally binding agreement between more than one person, or more than one person in a corporation, or 2 corporations. So you have to have at least 2 people or parties to make it joint, but you could have more. Like, so Aisha, Sarah, and I could all be parties to the joint venture agreement. So it doesn't have to be limited to 2. It could be 2 or more. It could be 3, 4, 5, whatever. And we could do it personally or in our corporations. But the joint venture is going to basically be the agreement that sets out our terms. So it's going to be things like how long is the investment project for? Is it a year? Is it 2 years? Is it 3? Is it 4? Is it 6 months? Is it indefinite? Or is there a more fluid term, meaning certain events trigger the end of the joint venture? So term is always a really important thing. After you've isolated who the parties are in the joint venture, the term is really important to nail down.
So guys, as you're talking to your potential JV partners, these are some things that before you sign a contract that you want to make sure that you are on the same page and you have the same goals as them, because sometimes you talk to JV partners and you guys both want to be active, or you both want to be passive, or one person wants to stay for 1 year and the other person wants to as a long-term thing, right? So we understand things happen, but this is really good information. You guys take a screenshot if you want, but these are things that you want to start asking your JVs.
Mm-hmm. And we have a question. We actually have a question from Anoop, and I think it's coming down to when you talk about the percentages, the split between active and passive partner. So at times we know there can be different splits. So in the situation where the split is 50-50 active and passive, the question was, shouldn't the money partner have a higher stake in the partnership? What's your thoughts on that?
Well, I mean, I think it just comes down to, fundamentally, as Sarah said, what's the agreement, right? I mean, if the agreement is that one party's supposed to have a higher, rate of return or have a higher responsibility of money in, money out. I mean, it's all what we agree to, right? So there is no hard and fast rule per se. I think it's all fluid on like what each project, entails and brings, and really, I guess what everybody's appetite is and what everybody's willing to agree to. Because we could turn around and say, yes, if I have more money in, I should get a greater return. And I would think, generally speaking, that is true. Or if my, input into the project is potentially seen as being more important, or is more onerous, or just of a higher percentage than the other, people involved in the venture, then it would make sense that that person should see probably a higher return. But it's all what you negotiate and what you agree with, right? And
yeah, it is what you negotiate and what you agree with. I will say though, most people, most active investors that have a large portfolio, how we see it in this market, again, it doesn't have to be the hard and fast rule. Like Ryan said, it's just however you guys agree, but it's usually 50-50. One person holds the financing and brings the money, and then the other person is the active partner, finds the deals, manages the renos, finds the tenants, manages the tenants, and so forth. That's pretty typical in the industry. It doesn't have to be a hard and fast rule, but that's a typical way that many people do it.
yeah, and I would agree with you there, Sarah, too. That's what we kind of see with yourself, as well as with just many others that we work with. People want it to feels like they're being potentially maybe taken advantage of, or they don't see that it's fair. Well, then it's going to be harder, obviously, for that joint venture to successfully come to maturation, or have it repeat with other projects, right? Because somebody is going to feel like they got taken advantage of, or their efforts weren't rewarded equally, those sorts of things. So most of the time, I totally agree with you that what you put in is what you get out, right? So if you only put in 30%, you're going to probably get 30% return, and vice versa. And if it's hard to determine like how much people are putting in, so to speak, because one person is let's call it like the sweat equity, and the other is the capital and money, it's hard to say which one is have a higher importance, or percentage wise. Just mostly we see like 50-50, or if it's the three of us, like I said, my example would be like we'd all get an equal third, right? So that's definitely what I think we see most often. But there can be certainly ones we have done where there's an uneven percentage based on agreed upon terms of the parties, for sure. So other terms that we would normally suggest, you've got the parties that are going to need to be listed, which can be the individual person or corporations. You've got the term, and then usually you want to talk about what is the project? What is the scope of the project? Is this going to be a one-off JV that only applies to a particular property, like 123 Smith Street, and maybe we decide we're going to BRRRR it? Or is it going to be a JV that is applied generally to multiple projects? Most of the time, I think we probably see it being more specific than general, but it is possible that it could be both. And that's why it's kind of important to kind of put the scope and so forth in there, so everybody knows what they're signing into. Is it the one-off project, or something that's multiple, or varying across several different projects and properties? Mm-hmm. And then you talk about essentially the distinction between roles. So is there going to be a distinct partner in this joint venture who is involved with the sweat equity, the management, and sort of the operation of the project? And is there going to be another who is more specifically focused on just qualifying for and being the one who goes on for mortgages, goes on for the financing, brings the down payment possibly. Those sorts of things need to be clearly sort of delineated in the project and in the joint venture.
We're getting a lot of questions about title. So you did mention that, you go over the list, see what part you're taking, and it sounds like one can qualify for the mortgage, but both do not have to qualify for the mortgage. Let's say there's two parties in the agreement. So that's cleared up. And then the question was, do both parties have to be on title in every agreement?
Well, so with joint ventures, typically only one group of the parties is going to go on title. So it's typically the money partner. So if there's myself and you, Aisha, and you're going to be the manager and the sweat equity and so forth for the BRRRR, and I'm going to do the capital and the down payment and be the one that qualifies for the mortgage, it would only be me that would be on the mortgage and then on the ownership of the property. If you do it just as a straight bare bones joint venture. So one of the things to kind of just talk about here related to specific terms of the agreement, and this might be familiar for some of you who have done joint ventures before, might not be familiar for ones that have never done it. But the banks, if you're using financing with institution or credit union, are leery of there being what are called beneficial interests of a third party in the title to a property. And so what that means is the banks don't want to find out later on that I'm holding title, yes, as one of the owners, but also for Aisha as a beneficial owner. Because then the problem is I only actually own half of it, for example, and Aisha technically owns the other half. And so theoretically, Aisha has a claim now over the property that they were expecting to have full security and interest over, because I was, in their eyes, the sole owner. But Aisha, you have a trust or a beneficial interest in the property. And so banks and credit unions are a bit leery of that. Private lenders obviously could care, as they might care, but they probably care less about that. And most of the time they're not worried about it at all. They understand that that's part of what's being structured, right? But banks are leery of it. Typically banks and mortgage brokers, if you're working with the financial institutions, they do require like disclosure of this beneficial interest. And so that's why it's important to make sure that you know that ahead of time when you're structuring your joint venture, because if that's going to impact the financing of the deal, then you need to make sure the joint venture doesn't indicate that there's this trust interest. Otherwise, if it's not going to be a problem for financing, then it's always beneficial for the party that's not on the financing and thus on the title of the property. It's always better to have this trust interest in the JV, because then now you have a beneficial interest in the property. There's more legality to that for you being a non-registered owner, right? That being said,
Ryan, I just want to jump in because that was really important. Like for me, you made me two separate agreements, one with the trust wording and one without. And so I think this is where it's important to know and differentiate when to use which one, so that you're not impeding the potential financing of one of them, right? And so that's a key thing. And I'll tell you, I probably learned that from you just not even a year ago. With it's actually important to have one with the wording and one without.
Yeah, and to your point, most of the time, if somebody's working with institutional lending, so the banks or the credit unions, you're probably going to have to utilize the one that does not have the trust wording, does not create a beneficial interest, because it's pretty standard boilerplate that the banks don't want there to be a beneficial interest in the property. Now, that being said, some mortgage brokers, depending on who you're working with and their expertise and knowledge and just how your application for the financing is coming together with them, sometimes they might, it might be prudent for them to disclose it, in which case If it's disclosed, then by all means, you could utilize that JV that has the trust interest. But most of the time, you're going to use a JV agreement that does not. And so the protection for the non-title holding partner in the joint venture is all right of contract. So it's all through the terms and rights and warranties and provisions of the joint venture that are going to govern what what rights and actions do they have in the transaction, and what rights and remedies do they have against their other partners in the joint venture if stuff kind of went sideways. So that's why having the joint venture and really putting some time into it and really making sure that what you've been talking about as possible, real estate partners, you want to make sure that the way you're talking about it is the way that you've written it out or your lawyers have written it out. And so other terms that should be included in the joint venture, other than what we've talked about so far, so parties, terms, possibly a trust interest or possibly not a trust interest with the beneficial ownership, scope of project, roles and responsibilities of the various different parties, but also would be, what are the capital requirements, both on the outset, so initial contributions of capital from all parties, but then also what about additional capital calls? What if the project you're working on, runs over budget? How will that be taken into consideration? What happens if one of the parties can't match what the other one's putting in? How does that get offset? So these sorts of things will be good points to make sure you've got in your joint venture.
Yeah, and one question we had was about cash flow. So
Mhm.
determining what the split is, the equities at 50-50, what is a typical scenario? And also another question in the same category is if there's a loss, how does the money partner recoup the losses from the working partner? So again, these are things that, right, you want to address during this time as well, or is that something you look at after? Is it predetermined? How do you go about?
No, I mean, you're absolutely right. I mean, those would all of those questions you're going to want to have and agree to in writing in the joint venture, before, probably before you get right into everything, right? So, the whole all the what ifs, right? What if we need more money? What if somebody can't put enough in? What if, the project's not going to come to fruition with the rate of return we expected? What if somebody else wants to buy in? What if there's another investor that wants to come on board? All these various questions should have answers for them within your joint venture agreements. Especially the best one is, what are you going to do if you need to get divorced, right? Meaning you guys need to, you can't, me and Aisha are joint venture partners. We don't like each other anymore, or we're going separate ways and do different projects. We need to, one of us needs to terminate the joint venture. How are you going to do that? What's the valuation mechanisms you're going to use to value what the project's worth at that point? How does somebody get partially, bought out, or, just
So
all
do
the
you
different.
have standard scenarios for each of these questions, and you'll have everything on the contract, and then you'll also, will the clients, whoever decides to come forward and make a JV agreement, they'll have the options to kind of get a few suggestions from you on how, other JV partners have handled these outcomes and how they could possibly adhere a few options. I think they're kind of asking, where do they come up with what's going to work for them?
Yeah, so we have our own sort of master documents that we've kind of incorporated a lot of all of this into it. So we're happy to work with anybody who's listening or anybody who hears this, in a recording or viewing afterwards. We're happy to work with anybody to draft all of it up. That's basically kind of what our job is, right? Is to take what you guys as investors are potentially talking to one another about, in the more informal and I'll call it simplified form of just conversation. And then we have to kind of put it in to make it, make sense from a legal standpoint. So when it gets complicated, is it very easy to follow a thoughtful process of this is how much money you have to put in, or this is how much money you get out, or these are the steps to terminate, or so forth, right? So we have about I would say at least about 100+ question interview that we do, that my one colleague Sean does. So it takes about 60 minutes. We ask about 100+ questions. And then with those answers to those questions, we're able to then flush out a joint venture that works for, the 2 or 3 or 4 people that are doing the joint venture.
Do you have a list of those questions that people can maybe purchase or get their hands on?
It's not something that we really sell just as a boilerplate, but we're happy to obviously have the conversations with people and then draft the documents.
Okay. Speaking of if things get complicated, I think this question from Nicole is probably a good time to ask. Do JV agreements, can they be used in court if needed?
Oh, absolutely. It's a legally binding document. So, joint venture agreements are 100%, as long as they're properly affected under contract law, absolutely you would utilize it as your arguments for your case in court if you ended up going to court against a former partner or so forth. But absolutely. So to have a valid contract at law, you need offer, acceptance, and consideration. So there needs to be terms of offer, and acceptance is signing, and then consideration is usually you'll see legal contracts say for consideration of $1 or $2 or $10. That's the requirement for the consideration. So JV agreements are entirely enforceable at court as long as there's not a reason they wouldn't be.
Okay. All right. And what about this question from Tim here? Succession planning. If one partner passes away, does that need to be, or should that be in the JV agreement?
Absolutely. Yeah. So kind of rounding out the terms that you would have in a JV, though, terms about death, disability of a partner, those would all be included within your JV agreement. Usually towards the end of the document when you're talking about, termination and also resolution provisions if parties are disagreeing, right? So all of that stuff those are kind of the terms that you'd want to see in the JV. The easy ones are always sort of how much money is somebody going to put in and then what are you going to get out, right? Those are kind of the easy ones for people, I think, to identify, because those are the simple conversations that are attracting you guys as investors to one another, which is I've got a project, this is what it entails, this is how much money I need put in, or this is what we need put in, and this is the rate of return you're going to get back. So those are the easy sales pitch items that you can talk about. It's the greater nuts and bolts of what if it goes over budget? What if you need more capital injection? What if there needs to be new parties or fewer parties along the way? What if we have disputes? How are disputes settled? What if ultimately at the end of the day we hate each other, or we just need to go different directions? How do we get quote unquote business divorced here, right? How does this work, right? Those are the less sexy conversations people want to have, because you're not having a conversation with each other to be hey, so how are we going to fail, right? Nobody does that, right? You're having a conversation because you're excited about your projects, you're excited about an opportunity, you have some money, you want to invest it, you want to make some money on your money. That's what everybody wants to talk about. But quite honestly, when it's good. Nobody's going to care, right? But that's why you need the agreement, because when it goes bad, it goes bad. And if it goes bad, one bad deal could kill 10 good deals, right? So or it could be worse, right? So at the end of the day, that's why people use lawyers, because it's our job to think about all the bad conservative stuff, like that's, we're trying to make people aware of their risks and their exposures and do what we can to hopefully minimize those sorts of things. And so, yeah, I mean, if people are interested in JVs, they think they need a JV, or they want to talk about them more, they want us to draft them or review them, we can do all those sorts of things for, anybody who's on the call or sees this later or what have you, right? But absolutely, like 100%, you need to have some sort of written agreement. I know that there are real estate investors out there that do everything on a handshake. And I know that for some of them, it works really well. And so that's amazing. I know there's some people that do it on like it's like a one-page napkin deal. And so, for those people that works, that's fantastic. But I think they're probably in the minority. Most of the time that won't work for people, either because people just aren't comfortable with that. They don't trust it. They're not built that way. Or they're just nervous, right? Like if you're a newer investor and somebody just gives you like a little one-page document with like, hey, give me $100,000, go on a mortgage, I'll give you 200,000 back. People are probably a bit skeptical of that, right? So seeing some sort of legal document, having legal review, I think makes people have a bit of comfort as well, as having something they can rely upon. So, I mean, those would be definitely terms that should definitely be in the agreement. There's obviously, you could customize any multitude of terms. Like I said, we have over 100 questions we ask people. So there's a lot of terms that could go in. It won't always be that substantial, but we usually go through all of those questions to make sure there's something that doesn't trigger or we don't miss something, right?
And now, Ryan, if you're going through this with the client, could the two JV partners work with the same lawyer? Actually, great question from Barb. Or should they each get, different representation?
Yes, no, it's a great question. No, like we would only be able to really provide, it wouldn't make any sense for them to both work with the same lawyer, because then you can't get independent legal advice, right? So like if you and Aisha are both doing a JV together and I'm drafting it for both of you, but you want to be able to ask me independent questions, I can't do that, right? I mean, if you both know and you acknowledge, hey, I can't give you independent advice, you just want me to draft it, I mean, I can do that. I can draft it for you. I just can't give you independent advice, right? Because you're both my clients and I drafted it for both of you. But the more prudent and conservative thing we recommend is, we just would act for you, Sarah. You would hire us. We'd do your JV agreement. We'd structure it all for you as you are advising us. We give you independent advice to any questions you have, and then it would be presented and provided to your possible partner, Aisha, and she would then take it to her lawyer and do the same thing. And it makes a good point to that as well. So some people don't want to do that because maybe it's more time, it's probably more money and so forth. I understand that. I can sympathize with that. The one reason you want to do that, though, is it makes that contract more enforceable, especially if like Sarah Larby is an experienced, real estate investor, and she's well known and she's teaching courses, and you're a newer one. And like, if somebody comes along and they want to work with Sarah and they're brand new and they're averagely sophisticated, like they're not a real estate expert, and it's their first JV agreement and they don't have their own lawyer, but Sarah's got this full legal package that's all done and so forth. If it went to court, the court might say that there was some unfair bargaining power here, right? And so for Sarah, if she's dealing with somebody who's potentially newer, or she might feel needs somebody to make sure this is independently explained, to it's always a great idea to make sure all parties have independent legal advice. The point is, it makes the contract more enforceable. If there was ever disputes about somebody might have kind of taken advantage of the other person, you can't have that argument, because at the end of the day, they had their own lawyer. If their lawyer gave bad advice, well, then that's their problem with their lawyer. But you can't say you didn't know what you were signing as far as the joint venture agreement goes.
Awesome. That's great. So we'll let you continue a little bit. I know there's a bunch of questions coming. We'll ask them shortly, but I know you have like a whole presentation for us as well. So
Sure. Well, yeah, I mean, like I said, there's not a lot of slides. So it's more just us talking about these points. And so I'm happy to answer the questions as they happen. Most of the probably 15, 20 minutes that are coming up here will still be about the JV, and then we can jump into some of the other structures as well. Because there are other ways to structure a real estate deal other than just joint ventures. But I just know that the joint venture is it's the least expensive option of all of them that we're going to talk about. And I know it's the one that people probably hear and read about the most frequent. So that's why we're spending kind of the first part on it and probably the most on it. So, sometimes you have a question of like, how basic or advanced does the JV need to be? I think we've sort of talked about this already, but I'll just try to, punch some points home here. Like our JV that we use is, like I said, we always ask those 100 questions. I mean, we might blow through 50 of them because 50 of them might not be very applicable to the negotiated arrangement between the parties, but we always ask at least those 100 plus questions, because we want to make sure that our JV is thorough and it provides coverage, but we don't want it to be overwhelming when somebody reads it. So we had to try to really pare it down so it's not 50 pages, but that it will cover all of the needs of the parties. And so I think from the list that we've just kind of rhymed off for the last 15 minutes or so about terms and conditions, you can see that I don't really know that there would be such thing as a basic JV. I think if you did like a one-page JV, you might be finding yourself, exposed and at risk to certain things from a legal standpoint, right? That being said, I know there's people out there that do handshake deals or very simple one or so page JVs. I'm not saying there's anything wrong with that. I just think there's some exposure there to things they might not be thinking about. A lot of times people just think about how much, who's involved, how much money's getting put in, and what's my rate of return, or what's my expected rate of return. And I get it. Those are the really sexy points of what you're trying to accomplish by being real estate partners together or in projects together. But there's the other underlying items that those are really, I think, where the meat and potatoes hit with the JV is you want to know, what if it goes bad? What if we hate each other? What if we need more money? What if the project isn't working out? What if there's a change in interest rates? Right? I mean, what do we do if these sorts of things are occurring? And how do we make sure that JV keeps moving forward and everybody's hopefully getting the rate of return or close to out of it? So could there be a basic one? I guess there could be. Could there be more advanced ones? Yes, I've seen ones that are for really big projects, like 50 pages. I mean, for most of you, we want to try to keep something within like 8 to 12 pages, so that it's encompassing, it provides minimization of risk, and all your terms can be there so that everybody knows they feel like it's well-rounded and balanced.
Yeah, and we've just had a few questions about the cost of a JV agreement. Does that vary depending on the complexity of it, or is there a standard fee? How does that work?
So we won't necessarily know how complex it will end up being until we start getting into it. So our fee to draft a JV is $1,500 plus any like office disbursements and HST. That's just our office. And that includes us basically doing an initial 15-minute conversation, 1-5, and then a further 60-minute conversation, a draft, and one revision.
And any document, sorry.
Once we go past one revision, all of the additional revisions are just at an hourly rate.
Okay. And if I'm coming to you to draft a JV agreement, what documents or what information, or do you have a checklist when I call to make that appointment that you'll send me and say, hey, when you come to the appointment, please bring this information or fill out this information? Any ways to prepare so it's efficient when we meet?
Yeah. So what we end up doing, that's why we'll do the initial 15-minute call. That's when we'll just kind of just have a quick conversation, figure out quickly with a couple of key questions we'll ask, is the JV going to be the right thing for you? And then should we proceed to like the more in-depth, 60-minute call? And then if we determine, yeah, it's going to be the right fit, then either on that 15-minute call or through email leading up to your second call, your 60-minute one, we'll let you know like what things you need to be thinking about, what questions you need to have answered kind of yourself, what documents you might need to bring to the call or the meeting. But we try to make it so that it's we just want people to show up and answer the questions, just like you'd be having a conversation with your investor, right? That's when we usually find we get the most honest answers to the questions, which then allow us to probably draft the best agreement, right? So we try not to do too much scripting at a time, but we will give people some information and some prep to help them for the 60-minute call. But the first call is pretty much just, let's jump on a Zoom, let's have a phone call, and we'll quickly figure out if a JV is the right fit. We might figure out in that 15 minutes it might not be. So.
Okay, awesome. Let's continue, and we'll come back to questions as well throughout.
Sure. So one of the other questions that we get is, what are some of the pitfalls you should be aware of when entering into the JV? And I mean, I think this is a bit of a broader question that, is not exclusive to joint ventures, right? It's kind of just whenever you're partnering up with more than one person, more than one corporation. I think you just need to generally ask yourself, do you play well with others? Like, are you going to be able to work well and interact with others? If you come to terms in an agreement, are you going to be able to honor and fulfill your side of the agreement? Because if you know that you're a person who, needs to kind of be involved in control and kind of do most or all of it, independently or individually, then, right away, any of these sorts of things aren't going to work well for you, right? I think the other thing too is the parties, when they're negotiating, if one party is getting too good of a deal, too sweet of a deal, then normally that deal is going to be doomed from the start. So parties have to feel like each party is getting, an equal amount of input and output, right? And so that's subjective. I mean, it's hard to know what other people think, but if you're wanting to try to entice, newer investors to kind of join up with you, and you want to be attractive as a person that they can, do business projects with, real estate projects with, I think you have to make sure you're being honest with yourself, to make sure you're giving them a good return. You're giving them a fair return. If you're trying to maybe potentially get a little bit more out of people or take advantage of people, then usually those deals end up being problematic. Those deals don't typically work out well, or they can get quite, problematic, end up in court, etc. Right? So the other most common pitfall that I think we see with real estate investors is, well, twofold. They either don't have anything in writing or very little. So that's one. Or number two, they've entered into the deals ahead of doing the document. And so that becomes a bit of a problem, because now you're trying to write the agreement after the fact. And that's when people could potentially like change their mind on, oh no, that's not what we talked about. We talked about this, or I remember it a different way, right? So whenever possible, and I know in the previous, let's call it market, where it was a seller's market, high competition, bidding wars, etc. That might still be possible in some areas, but I think it's changed. The market is changing at this point. But it was really fast. And if you stop to think, then you lost the deal, right? You would not be able to get a deal. But now with the market being let's call it a bit more conservative, or a bit slower, you should be able to have time, hopefully, to enter into these arrangements beforehand, and hopefully find the projects as you go, right? Not always, but if you can enter into the terms of the JV at the same time the project is coming to conclusion or starting, it's always better to do it prior to everything being legal and registered. Then everything gets done, and then you're like 6 months later, oh, we have to sign this JV now. That's always a bit more difficult to deal with, especially if things start to get sideways, or there's disagreements, or people remembering different points of view of what they were going to enter into. So those would be probably the most two common pitfalls that we see is with JVs is people just don't have them at all, or they're not in depth enough. And that doesn't mean 50 pages. It just means that they've considered sort of all the different possible issues that need to be addressed, or they're dealing with the joint venture document late in the process, after everything's become potentially maybe registered and acquired and so forth. So dealing with it after is not ideal either. A question we get with joint venture agreements is, how can you litigate the problems when they arise? And so these will be terms in a JV, typically can be like the dispute resolution section. And so a lot of times people will particularly try to agree that litigation isn't an option. So they'll try to contract into like mandatory mediation or alternative dispute resolution to keep it kind of out of the court. So it goes to a mediator, and then that mediator's decision is final if it had to, right? But other ways, that you could deal with problems in the joint venture agreement is have really detailed sections about exit valuations and exit buyouts and exit strategies, so that if certain events do come up, hopefully they don't, but if they did, then it's sort of automatically already agreed to that if this event happens, that this is how the buyout is valued, and then the one party has to buy the other one out if that's the wording. So if people have been involved in businesses before, partnership agreements and shareholder agreements commonly have this kind of wording, so that the whole point is you're trying to avoid the costly and time-consuming process of litigation in the courts, and then to a lesser degree, even ADR, alternative dispute resolution, and mediation is a time-consuming and costly process, although not as long and expensive as litigation. It's still going to take a while, and it's still going to cost quite a bit of money. So if we can proactively minimize litigation through the contract itself, that's always beneficial. But I think the question earlier was, if you needed to litigate, and use the contracting court, could you? And you certainly could, as long as it's properly structured and put together.
Yeah, for sure. So just from a time standpoint, because I know we have about till 8 o'clock, and then we're going to open it up for questions. We have a ton of questions. Like literally, I think, Brian, what we're going to have to do is we're going to have to do another webinar again. And because there's so much more than just JVs, right? I mean, JVs is a good one to get started, but then there's we can get started about GPLP structures. We can talk about shareholder agreements, which are different than essentially the JV stuff. Like there's actually this could be maybe a 10-hour conversation on a webinar because there's so much. But you know what? There's a couple things here that I do want to ask before we move on past this JV stuff. But what if somebody puts a lien on that property? What happens from a JV situation? Like let's just say a contractor liens on the house.
Well, I mean, so again, it probably comes down to what terms are in the joint venture agreement themselves, and why or how did that lien get registered, right? If that lien was registered because of the failure of one of the parties to fulfill their roles and responsibilities in the joint venture agreement, then within the JV agreement, there should be terms to say, what happens, what are the consequences then of that, right? And I would presume there would be some sort of offset to the party who failed to deliver their full scope of service under the JV. There'd probably be some offset to maybe the rate of return that party got, or there might be wording or provision in there that sets out this is how the JV will pay out the lien against the property, but then how it is offset against, again, if there's a defaulting party amongst the JVs, that would probably be, the active managing partner. They probably made a mistake. They failed to do something, whether they knew about it or it was inadvertent. It's probably that, managing partner's error that's caused the lien to be registered. But the bottom line is it's liened against the property. So you have to do something about it. And so the question would be, what terms are within the agreement that help solve that problem, right? But I would assume there'd be some sort of offset if there's a default by one of the parties. If there's been no default by any of the parties and somebody just registered a lien, then you'd probably have to treat it just like you would treat like paying off a mortgage or something, right? At the end of the project. Again, the question is, really the big question is why did it get registered in the first place?
Okay. All right. Awesome. Okay. We've got 6 more minutes for you to go through it. And then here's what we're going to do, because I know there's tons of questions. At the 8 o'clock mark, I'm going to ask you guys to raise your hand if you want to speak, and I'll allow it says a little button that says allow to talk. So you guys will get a chance to ask Ryan your questions. We'll do that right from 8 onwards for about 20 minutes, but we'll just let Ryan continue with his slides for the next 6 minutes. Can you do that in 6 minutes? Probably not. We'll have to do another webinar, right? Go for it.
I can't do anything in 6 minutes.
That's true.
So I will, I mean, a lot of these questions I think actually we've already addressed. So the one thing I'll do is just quickly show this slide, because it actually goes into sort of what you talked to, which is we've talked a lot about JVs. So that is one legal way, one legal structure that can allow you as real estate investors to partner up with more than one other real estate investor and have some fun out there and do some projects and be successful, right? There are other ways of doing it. One other common way is through a corporation, like actually have a corporation own the property, and then all of you be shareholders of that corporation. And so very similarly to the joint venture agreement, it's just called something different. You'd have a shareholders agreement, which would be basically your joint venture for a corporation. It would be your legal document that says what all the parties that own the corporation are going to do, right? So very similar to a JV, it's just in a corporate structure. It's in a corporate shell, right? And so sometimes that might be attractive for people to do as opposed to doing a joint venture. because of maybe financing. There might be financing reasons and benefits to do it all through a corporation and have everybody as shareholders. Maybe there's more financial buying power, right? Or there could also be the whole purpose of, if you remember back to when I started, the JV commonly won't allow certain people to be registered on title, because then the money partner is going to be on, because they're going to be for the bank and the mortgage. The active managing partner is not going to be on because they don't want to be on the mortgage. But that managing partner, the problem for them is, if they don't have the trust interest, they don't actually have anything that binds the title. They have contractual rights against the person who owns the property as their partner, but they don't have that ownership, that deed, like you would if you were just on the property. And so that's where setting up corporate structure can give people some greater comfort, because if you're an owner of the corporation that owns the property, well, there you go. You've got the title, like you own it. The drawback is all those shareholders are probably going to have to go on as guarantors to the mortgage. So every option that we're going to talk about here have their pros and cons, right? But those are some of the differences with the corporate structure that some people like or dislike to the JV. And then the document you have for the corporate structure is a shareholders agreement, as opposed to a joint venture. The last one, I won't even talk about trust, because that's probably just more complicated than we need to get.
I was going to say, there was actually a question from Napul that wants to know about the Bear Trust. So just quick, like 30,000 foot view. What are like the, just two.
So make that the first question we ask in 1 second. After, I'll just say what GPLP is. So GPLP, if people have never heard about that or read about it, it's a general partnership, limited partnership structure. So these are really common and becoming more common, even so, with like development projects, and I'll call them like larger, like sort of apartment type acquisitions. So you're not going to do GPLP for like duplexes, tris, quads, even 6-7 units like by themselves. It's probably not going to be a GPLP structure you do. Most real estate investors that we're working with that utilize the GPLP structure are like, they're buying plazas, they're buying apartment complexes of like 20, 30, 50, 100 units, these sorts of things. Or they're buying land and they're doing like a development, right? Whether they actually do the build themselves or they get it to a certain point and then sell it to the developer. The GPLP structure, it's the most expensive and legally complex to set up. So it's, probably 5 to 10 times more expensive than the JV. It's probably 3 to 4 times more expensive than the corporate. But the benefit with the GPLP structure is because of the highest level of complexity it has, it probably has the greatest opportunities for different tax plannings to happen, as well as it allows the general partner to manage everything similar to like what's happening with the JV, and more quickly and aggressively raise capital from non-arm's length parties, like third parties, because you're basically selling units or investment opportunities in the partnership. So basically there's this big partnership vehicle, there's a general partner who operates and manages it, and then all the people that are out there in the world are your limited partners, possibly. And you're going out there basically selling them on, here's the investment opportunity, I need $100,000. You buy, you sign up as a limited partner, you get the units in the partnership, I manage everything, it's completely passive to you. The only risk you have is you lose your 100K if the thing's a flop. Or, it does everything we are advertising to you that it will do, and you're going to make your 100,000 back plus, 2x, 5x, 10x, whatever the return is, right? Whatever that whatever that draw is. And so the reason people like this GPLP structure for those development projects, those bigger projects, is you need higher levels of capital, typically from more sophisticated passive investors. The key thing to note about the GPLP structure, if you're, wanting to scale into those larger projects, or you're trying to do some of those larger projects right now and you're having trouble scaling the capital, because not everybody has like a golden goose or something like that, that's just got deep pockets. You need to make sure you have properly qualified yourself so that you're exempt from the Securities Exchange Commission of Ontario. So you need to make sure you're not seen as selling securities and investments without an exception to regulations of security exchange. Otherwise, you're going to have the OSC, Ontario Security Commission, crawling all over you. So
that would not be a good thing at all. You don't want to get into that mess.
But, rest assured, there's lots of people doing this. Like, there are a lot of investors doing GPLP structures and doing it very successfully. And they're making sure they have all the exemptions under the, securities regulations in Ontario. And they usually utilize the services of what's called an exempt market dealer. So they help, the exempt market dealer will help you make sure you're on side of all those sorts of obligations and rules that relate to securities law for Ontario and the securities exemptions. And then the lawyers typically do the structuring and the agreements and so forth for the GPLP structure. And usually, of course, you need to have some tax accountants chime in on what some of that structure should look like.
Okay.
So, I mean, because we're probably at 8, right? I probably didn't say that in 6 minutes, right? Those are the other structures, that I'm happy to answer questions on. I know most of the first 50 plus minutes was really about, joint ventures. And really that was designed on purpose because I know most people, I think there was quite a few no's in the chat about like who's used them, who's not. I mean, most people, whether you're new or starting to scale and grow in real estate investing, most people work with JV agreements at least once or quite a lot at the beginning because they're the least expensive to set up and they're really applicable to any situation. Like you could use them for the big developments and the big projects, but you can use them for like a duplex or a burr or a flip or whatever, right? So they have the greatest application. It's just that some of these other structures are a bit better suited as you potentially get into different types of projects, especially bigger ones.
Okay. All right. Awesome. So Ryan, what is your best way to reach you? So for anybody that is interested in having you maybe review one of their current JV agreements that they have, make your suggestions, or, like any of these structures, more information, what's the best way to reach out?
I've just put my email and my website on there. And I think also we've got we've got stuff on Facebook and YouTube and stuff on different channels. So, but if you go to our website, you can get different resources of where you can watch some of this other stuff, but you can also just email me. That's the best way to reach me. And then once I've got an email from you, I can make sure we have follow-up meetings and or files opened and so forth, right? But email is the best way to get me.
Awesome. And I do find that it's easier to work with, like for me anyways, I like simplicity in some things because I have a lot of different projects and a lot of businesses going on, to have you for my closings and as well as my JV stuff, as well as the corporate, setup and stuff. It's just, to me, it's just a lot easier. I like to delegate and if I can have somebody that can do all of it, that's very, very valuable. So Ryan, thank you so much. We're going to open it up to questions. So here's what we're going to do for questions. And I know there's a ton that we didn't get to. Raise your hand if you do want to ask a question, and I'm just going to put the button so you guys press the button so that you guys can actually ask your question verbally.
Do you want me to stop? Do you want me to stop sharing my screen? Is that easier?
Yeah, let's do that. Let's stop share. And do you do VTB agreements as well? There's a quick question there for.
Yeah, absolutely we do. Yeah, so vendor take back financing, absolutely. So, whether the terms are written ahead of time into the agreements of purchase and sale and so forth, or we need to like enter into those terms, after the agreement's been struck, because whatever financing is required, then we can do both. Yeah, absolutely.
Okay. All right. Awesome. Does anyone want to ask a question live?
I know, Sarah, you wanted me to, just so we don't forget about Bear Trusts. So maybe I'll just talk about
You know what? That's perfect. Let's do that.
So the question about like, what is a Bear Trust agreement? So the Bear Trust agreement, some people might read about it or hear about it out there in the real estate investor circles, is basically it is a pretty simple document. It's like 1 or 2 pages. Is basically just a document that indicates that somebody is holding registered title in trust for another person and or corporation, either in full or part, right? So, but again, this is where you need to be careful with your financing, because just like having the trust provisions within your JV, like the banks and credit unions don't like, they also obviously don't want you to have like a Bear Trust agreement, right? So commonly, the lawyer that closes like your real estate purchase probably won't be able to register for you like a Bear Trust agreement, because they will also at the time of the closing be retained by your bank, right? So most lawyers that practice real estate law, they get in a joint retainer with people who are buying and the financial institution if it's a bank or credit union, unless it's commercial, in which case the banks are typically independently represented at that point. But the same lawyer that does, say, a duplex closing is probably not going to be able to turn around and like prepare and register a Bear Trust agreement for, let's say, Sarah's taking the mortgage. So Sarah is buying a property, I'm closing it for her. We register it and everything like that. And then afterwards, Sarah, she doesn't tell me this because I don't want to know, but Sarah will basically be like, Aisha is also my partner. So Aisha, we're going to go to John Smith now, and John Smith's, the lawyer, is going to register us a Bear Trust agreement. And then Aisha basically has a 50% trust interest with Sarah, even though Sarah is the sole registered owner. But I couldn't do that as the lawyer closing the deal because I'm also acting for Sarah's bank. So, but that's what a Bear Trust agreement is, basically.
Okay. All right. Awesome. Good. So let's do a couple more questions. What about new construction? I see you guys like to add questions in the chat. That's totally fine if you're more comfortable. New construction. So let's do 2 things. Do you do new construction projects from a JV standpoint, but also I think people might be wondering if you also review builders or developers contracts as people are looking to buy these new builds, right? Condos or whatnot.
Yeah. So we do both. So that's the short answer. We would do both. So we can help do joint venture agreements related to like development projects, but we can also review somebody buying, from a builder, if maybe somebody's buying speculation, purchases type of thing. I mean, one thing I would just say on that, because it's a bit of a hot topic in the news, if people have seen this, I think it's kind of spawned out of the end of COVID, right? And one of the issues people are having with builders right now is builders have written to buyers and said, hey, we still have probably another year or 2 to close your purchase. But there's no way we can sell it for you at 500,000. We got to sell it to you at 700 now. And the builders were using sort of like COVID, supply chain issue, cost of expenses of contractors and materials and so forth. It's not feasible for them to sell it anymore at the price you agreed to buy it. and you've been sitting on this project for like 3 or 4 years, right? And so that has prompted legislative action by the government. So if you do a Google search, there's some great news out there about it. Long story short, the government instituted a piece of legislation. I forget what it is, but it's about home builders acting fair and equitable, and basically sort of penalizing them if they take on these practices of trying to artificially increase the purchase price because of those reasons of like supply chain and material increases and stuff. So, I mean, that's never ever been something in 16 years of practice that anybody's ever had to really worry about, because the market's always gone like that, right?
Right.
Prices have always been going up. Why not buy a house for 400,000 from a builder, sit on it for 3 years, and now I can sell it at 700, right? Or whatever. And so for the first time ever, that's and the builders costs of like building weren't out of whack, right? Like they could budget it and it was fine. What they encapsulated in the price of 400 was still totally fine for them. They were going to make money. The problem is with what all went down with COVID and everything, and just materials going through the roof in costs. At least, from what we're hearing from the builders, the reason, this has happened is they're out of whack now. And so the builders are trying to find a way to renegotiate the price. And so I think it's important it's always important, but really important now that this is news, to make sure if you're buying from a builder, to really look at what are the builder's conditions in a deal. Normally people didn't care because, like I said, you're happy to sit on it for 2, 3, 4, or 5 years, and you knew you're going to have a property that, as long as you closed on it, you've made lots of money on it because it's appreciated like crazy. But now the problem is, what could the builder use to get maybe out of this deal or rewrite this deal? Because in all of those cases, we reviewed a lot of those contracts after the fact for clients, and they asked, like, can the builder do that?
Right.
And quite honestly, the answer was they could, because there were conditions in the agreement that allowed for them to walk away from the deal for financing reasons. And so they built it all around, they weren't able to finance the project properly, right? And that's why the government stepped in, because the government was basically, seeing the general public being like, oh, this is legally allowable, but maybe not right. Or we're concerned there's a fairness issue that's being, overlooked here. So builder deals, I mean, sorry, that's a bit long-winded and maybe a deviation, but it's pretty new. Like I think that first hit the airwaves, excuse me, like this April, May, when some builders first kind of did this. And I think it's just kind of had a response just towards the end of summer, early fall from the government that, you can't do this. Now, I think the only repercussion against the builders are fines. So it's not like, I don't think, the contract gets overturned or what the builder's doing is overturned. I think they're fined. I think that's the penalty. So, yet to be seen, like, how impactful that is, right? But so builder deals are definitely something we can do. Happy to review it. I think if you're out there, whether you have a lawyer look at it or not, whether it's us or somebody else, make sure they focus on what are the builder's conditions to the deal.
Right. I mean, and usually with these new deals, you have like a 10-day due diligence period on the majority of the time, right? Where like you can take it to the lawyer and stuff like that before it goes firm.
Yeah, with builder deals that are condos, it's statute based that you get 10 days. You have to, under the condo legislation, whether it's in the contract or not. Freeholds is not, there's nothing legislated. So 5 to 10 days is typically what you'd see for a review. That's right.
So take that to a lawyer. Just make sure that there's or even limitations to even like fees, right? There's some fees you can cap some of the fees.
Absolutely.
Sometimes, like, so this is the fact, like, you could hire a lawyer to even just help you cap your fees could mean saving thousands potentially down the road.
Yeah, and probably tens of thousands now, because when I started practice, if people have bought from builders before or read about it, levy increases was the big ticket thing to try to cap. When I started, a levy increase might be $1,000. Now we're seeing them come in at like $20,000, $30,000, $40,000. Most people can't budget for an extra 20 to 40,000. So
okay. All right. So it's 8:16. I know that there's lots of questions. I mean, congratulations, guys. Like, you guys are very engaged, and Ryan, thank you, because this is a very engaging topic, and I think it's very relevant to the investors on the call, and whether they're doing it currently or they're planning on doing it. It is a great way to scale. It is not the only way to scale, but it is a great way to scale.
I think one question that Vinny posed earlier was, how long will it take for a JV agreement to be formed? So if I know I'm entering a JV agreement, how in advance should I come to you? Because as you mentioned, it should be done before the closing. So what time frame do I need to give so that we have enough time to go through all those questions, see what fits our particular circumstances, and have that done and ready for closing?
Yeah, I mean, it's all a bit dependent on sort of like volumes. I mean, obviously over the last couple of years, like, the volume's been insane because of how much real estate's was going on. So our timelines were probably a bit longer. Now with the volumes kind of slowing or potentially decreasing a little bit, means it's potentially a bit quicker. I would say at least 2 weeks, but I budget 2 weeks of time. That gives us time to do the things we need to do, like conflict checks, to make sure we, if we're going to say we're going to act for you, Aisha, we got to make sure that, we don't already act for Sarah, right? If that's the other party. So we have to do conflict checks. Then there's just the administrative stuff that we have to do to open a file. And then there's the 2 phone calls, right? The preliminary one, and then the secondary deep dive one. So all of that's going to take at least probably about a week to do. And then once we've got all that information, then it's putting it into, a draft to then further review and hopefully potentially finalize. So at a minimum, it's probably 2 weeks. We might get lucky, and for some reason it might be a bit faster, but at least 2, possibly maybe 3 weeks.
And another question was, can we use someone else at your law firm, another lawyer, or should it be from 2 separate law firms?
Oh, for like independent legal advice? I think ideally for it to be independent, it should be 2 different law firms. That being said, we do have more than one real estate lawyer at our office. So it is possible in certain circumstances that you could have independent legal advice, from the same law firm, different lawyers. I'm just trying to scroll through the chat too, just to see what questions.
Yeah, if anyone wants to say their question, well, we'll let you speak.
There was one question, I think it was from Abai, about sharing profit in corporations. I think it was, and I don't know if it was when I was talking about corporate, like owning it through the corporation, or if it was through a different structure, but
here we go. Hang on, Abby wants to talk.
There you go.
There we go. Go ahead. Unmute yourself.
Can you hear me?
Yeah.
Yeah.
Okay, good. Yeah, it was when you were talking about the corporation, because I have done something similar recently, but it was very messy. We did not realize we had to pay taxes for the corporation and all of that. So I wasn't sure. And right now, I'm still not sure how you share profit. And if you were going to have a loss, how do you also share that? Is it going to be part of the JV agreement, or is it part of the company articles? And, not sure.
Great question.
Yeah, it's a good question. And I mean, it's probably going to be hard to answer with in a lot of detail, because there's so many layers to kind of the scenario that it sounds like you're in. But so if the corporation is the sole owner of the property and you guys as investors are all shareholders in the corporation, then the way you would share profit or loss is going to be found in your governing document, which is the shareholders agreement. So that's where you like input, for how all the shareholders of the corporation, and the shareholders are the owners of the corporation, like how they're going to be responsible to share for losses or for profits, just like you would write that in a JV scenario as opposed to corporate scenario. So it's all going to be spelled out in your shareholders agreement, or that's where you want to spell out all of those sorts of things in your shareholders agreement. And then obviously, in an ideal world, maybe not as easy right now because you're already kind of in a bit of a, I don't want to say a mess, but like you said, you're already kind of in the thick of it. It's less easy to do it now than it will be maybe when you do your next opportunity or project. Maybe if it's possible to do more conversation and planning with like your lawyer and or your tax accountant ahead of time, because then they might be able to more appropriately suggest structure for your corporation for how you want different investors to invest into the corporation and the project. Because depending on how you're corporately structured, that will also have an impact on like who has what obligations and responsibilities for things like taxes and losses versus sharing in profit and so forth. Because you can have shares that are just equity based, right? They're not like ownership based. They don't have like voting say. They're just equitable interests versus creating different structures of like return as well. So there's, like I said, that's a bit of a high level answer because there's a lot of layers to how that could go. But it all would come from hopefully the next time. It's hard for you right now because you're in the middle of it, but hopefully the next time you do it, it's just more proactively planning that shareholders agreement and then the structure of the corporation.
Mm-hmm.
Thank you.
Awesome.
You're welcome.
Thanks so much, Abby. I think Daniel also has a question, verbal question, which is nice because I'm not talking the entire time. Ryan or Aisha, you guys get to talk too. So I'm going to bring you on and you can ask your question. Oh, there we go. All right, Daniel, feel free to unmute yourself.
Can you hear me now?
Yep.
Oh, perfect. So thank you, Ryan, again for the webinar. I guess my question is, in terms of corporations, is it possible to structure a JV between two corporations? So kind of the opposite of like having.
Yeah, 100%. You can have a JV between two people, two corporations, a corporation and a person, or like 3, 4, 5, 6. There's no maximum number. You just need to have at least two parties because it's a joint venture, right? So you need at least two, but it can be between individual persons or corporations or a mix of people and corporations.
And then would there be like any disadvantages to doing that?
Disadvantages?
Like the two corporations,
No.
especially from a tax perspective, I guess.
Yeah, I mean, from a tax standpoint, I'd have to kind of defer that to a tax accountant. I wouldn't be qualified to give you an answer of like
and probably from a financing standpoint as well. Check financing too.
Yeah, so I wouldn't know from that standpoint, but I mean, bottom line is that would be part of like maybe the early stages of your planning would be to sort of say to the accountant, hey, my goal is I want to try to do 5 projects this year, and I want them to be 5 burrs or something like that. And I'm going to partner with people for all of them. should I do all my JVs in XYZ corporation? What are my benefits from a tax standpoint if I do that? Those sorts of conversations would probably be good proactively with your accountant. And then once you know what she is suggesting, then you'd be able to go and probably tackle a whole bunch of investment opportunities.
Okay, awesome.
Thank you.
Thanks.
Perfect. We have a question from Barb. I can read it. Can you have more than one exit strategy on your JV agreement, a backup to the backup?
Yeah, I don't see why you couldn't. I guess it's just a question, I guess, of how many backups or layers are you going to have. I mean, I guess that's all going to be part of just the more finer details of the negotiation, but there's no reason why you couldn't. Yeah, there's absolutely no reason why you couldn't. I mean, if you use a shareholders agreement as an example, shareholder agreements will commonly have like probably 2 or 3 like buyout options for shareholders. Like if you're somewhat familiar with shareholder agreements, you probably have heard the term like a first right of refusal or a shotgun clause or tag alongs. These sorts of things are all different kinds of strategies given different types of situations that can trigger the opportunity for sort of like buyouts and so forth, or exits or whatever. So to your point, absolutely, you could definitely have more than one layer of an exit strategy, and you probably need several because you probably have several different reasons on why you might need to exit.
Mm-hmm. All right, so we're going to do one more question. For the new build stuff, can consumers get their deposit back if the builder cannot deliver on time or increase the price for freeholds?
So the price increase bit, what we've seen from the builders, if that's something the builder ended up doing, what we've seen in that scenario is the builders were offering the deposit back with some interest. So that's kind of the short answer there, because that's really a completely new situation. But that's what the builders have been offering is saying, hey, we'll give you your deposits back plus like 3 or 4% interest or something like that, right? Mm-hmm. There is wording within the agreements that state if you take too long and you go past a certain date and it's within the carry-on warranty schedule of a builder agreement, it's called the outside closing date. If you go past or you hit that point, then there's a 30-day window from that date that allows you to terminate with no repercussion or anything. You get your deposit back plus a statutory amount of interest. But it's definitely like a long window from when you'd sign the deal, right? So if you've signed the deal at the beginning of the project and it's like a 2-year project, the outside window is like probably almost 2 years after that 2-year closing.
Got it.
So it's certainly not anytime soon. Like a lot of time would elapse before the outside closing date would probably get triggered.
Mm-hmm. Tons of great questions. I'm sure there'll be more, guys. Ryan at carsonlaw.ca. If you need anything from anything that we discussed today, or closings, or corporation setups, or structures, or all of that good stuff. And then there's lots more from Ryan at our multifamily investor show that is on YouTube, and Ryan gets interviewed every single episode by us, asking him real estate legal questions. And the other thing is, if you have questions and you want us to ask the questions in a future show, let us know, because the show is also your show. So put that in the comments on YouTube. Say, hey, next time, girls, ask Ryan these questions, and we'll make sure to incorporate some of them into the future show. Brian, thank you so much for being on. And guys, there's lots of stuff coming up. So if you are on my mailing list, keep posted, because we are going to be providing some really cool, other webinars, other events that we're doing other courses that we're doing. So I hope you guys enjoyed everything today. Ryan, thank you for being an awesome lawyer. Thank you for doing all my transactions. Really appreciate it. Aisha, thank you for being my sidekick as well. I don't know how I could go back now, now that you've been around for about a year. Awesome. All right. Well, thanks very much.
Thanks,
everybody.
Ryan.
Take care.
Thank you. Thanks,
Thanks
ladies.
for everyone who attended too, and all the great questions.
And this
Yeah,
will be
thanks.
posted on the YouTube's channel in a couple days, so you can do your rewatch as well.
Perfect.
Bye, guys.
Thanks, everyone.
Thanks.
Bye.
Good night.
Night.